I need to speak with you about Canada's new anti-spam legislation and the effects that it has on realtors and sending out what the legislation refers to as CEMs, or commercial electronic messages. There's a number of things that realtors need to know because the fines are actually quite significant when it comes to what the CRTC can impose on realtors, up to $10 million for being found to be in contravention of Canada's new anti-spam legislation. So obviously the risks are high, and therefore you need to know what affects us as realtors. First off, there's a number of questions in the brochure that I'm going to put a link to at the bottom of this video, but in particular, what is a CEM? What constitutes a commercial electronic message? Secondly, is it subject to the CASL legislation, the Canadian anti-spam legislation? Third, has the receiver given us their consent to receive it? Fourth, does the CEM contain the required information that is now required for all commercial electronic messages? And fifth and finally, does the CEM contain an unsubscribe mechanism, a way for people to opt out of the information that you're sending to them? So the first question was, is this a CEM? Does this message constitute a commercial electronic message insofar as it pertains to the anti-spam legislation? And so what constitutes a CEM? Well, it's essentially any commercial information relating to the sale or promotion of a product or good or service. So for us as realtors, that really relates to either self-promotion, stuff that says, I'm a great realtor, you should use me to buy or sell your home. Secondly, it relates to things like open houses or new listings or just solds, all those kind of things. If you're going to send them out electronically via either an SMS, a text message, a email campaign, or some social media sites, those things all constitute commercial electronic messages. Finally, does it ask an individual if they're interested in buying or selling a property? If we're asking them for that information, it would constitute a commercial electronic message according to the anti-spam legislation. So while all electronic messages are considered to be subject to the Canadian anti-spam legislation, there are certain exemptions that you need to be aware of as realtors. First and foremost, messages that relate to a transaction. When you're dealing with the sale of a potential property with a buyer or seller or other realtor, you don't need to seek the consent of those realtors in order to get the information back and forth, and your messages don't have to comply with CASL. Secondly, messages sent to somebody who the sender has a personal relationship with, either a family member or a friend. Anyone in your sphere, people that you have a personal relationship with, those messages don't fall under the guidelines of CASL. Third, messages sent to inquire about a product or service. If you're asking another realtor about information on their listing, that doesn't fall under a commercial electronic message that would be subject to CASL. Messages that are sent to an inquiry or complaint about a product or service. So when someone contacts you to ask information, your messages don't have to line up with the CASL legislation. Messages that are to communicate between employees within an organization. So if you're going to send me a message or I'm going to send you a message as a realtor at Prudential Sussex, we don't need to worry about the anti-spam legislation. Messages that are to communicate between employees of two organizations that have a relationship. So in other words, if you're dealing with a realtor on the other end of the phone that has a listing you're interested in, they're not, or sorry, not the other end of the phone in this case, at the other end of the email, we don't need to worry about CASL legislation. However, if you're sending out promotional information to realtors in a blanket email, just promoting your goods and services, just because they're working with another organization that is within the same industry, doesn't mean that it isn't subject to CASL. So be careful, there's a differentiator there. If you're dealing with someone on a particular property, CASL doesn't apply. If you're just sending out promotional information about your listing to realtors, it doesn't give you carte blanche to go ahead and pursue those realtors with electronic messages that don't conform to the CASL legislation. And finally, messages sent to enforce a legal right, we also don't need to worry about those complying with the CASL legislation. So once we've established that the commercial electronic message is in fact subject to the Canadian anti-spam legislation, in other words, it doesn't fit into one of those exempted categories we just talked about, then we need to define whether or not there has been consent given from the receiver. And that consent can come in a couple of ways, either express consent, where they go ahead and click on an opt-in on your website, or they've said, yes, please send me more information, or it can come by way of implied consent. And there's 5 different categories of implied consent. So let's take a look at those now. First off, implied consent could be a referral. So if someone suggested that you get in touch with John Smith at johnsmith.com, you can go ahead and send him an email. The first one is free. First one's not subject to the Canadian anti-spam legislation, so long as you refer to the person who recommended you get in touch with them. So if someone gives you a referral, go ahead, send out that email or text message introducing yourself, promote your services all you want, let them know that you're available to help them, ask if you can go ahead and provide real estate services to them without having to sweat the anti-spam legislation, but be sure to note who it was that gave you the referral, and then you get that one strike for free. The second kind of informed consent would be people that you already have an existing business relationship with. So that's people who you've done business with in the past that you continue to maintain an ongoing relationship with. So let's talk about your database for a minute, people who you've been sending out information to regularly. And if you haven't done so in the last 6 months, that's actually an important time frame. You should send out an email promptly before July 1st, 2014 to establish that business relationship so that you have a 2-year grace period wherein you can continue to send them information so long as you give them the opt-out function. You can continue to send them information relying on the implied consent, which means they haven't told you to turn off that switch. So if you haven't already done so, I would send out an email broadcast to your entire database. Maybe send them some information on the anti-spam legislation. Give them some information and a link to this brochure so they understand what they can expect to receive, and get in touch with them. Now you've established that business relationship. You can continue sending them information for the next couple of years unless they say, please turn it off. The third kind of implied consent would be where we have a non-business relationship. So for example, if we're working with a political group or a church group or a school group, something that we're volunteering on, some other kind of board or professional organization, then we can go ahead and send out information to those people so long as we have an established relationship with them. So it's a non-business relationship, but a relationship. Again, we get this 2-year grace period where we can continue to send out commercial electronic messages without having to worry about scrutiny under the legislation. Fourth, the recipient may have conspicuously published their email address and not specifically asked you not get in touch with them with solicitation. So let's take, for example, a realtor's website that says contact Joe Smith at joesmith.com for more information. If they've conspicuously published that and haven't put anywhere on the website that you may not use that email address for business purposes, then you can go ahead and use that. And fifth, finally, if the recipient has gone ahead and given you their electronic email address or contact information, and has not specifically asked that you don't send them information, you're fine to do so. So let's take, for example, a business card. Here you go, Alan, here's my business card. Unless they tell you, please don't send me anything, you're fine to go ahead and communicate with them using commercial electronic messages. However, you still have to give them the opt-out feature so they can say, okay, that's enough, please turn it off. So if we can't be satisfied that we have implied consent by way of the 5 things that we just spoke about, then we have to go ahead and establish expressed consent of the consumer. And that means they have to physically acknowledge and accept the fact that they're going to be receiving this information. A good example would be click here to receive my newsletter. But you also have to put in that little click here to receive my newsletter the fact that they're going to have the option to be able to unsubscribe at any time. The other thing you need to provide them with is your name and contact information. So your mailing address along with either a telephone number, a web address, or an email address. So those are the 3 optional items that one of those 3 has to be included in it as well. In other words, you need to make it easy for consumers to get in touch with you when they want to respond to a commercial electronic message, and you need to make it easy for them to opt out. And fifth and finally, does your CEM contain an unsubscribe mechanism? This unsubscribe mechanism has to be easy and has to be obvious to allow people to opt out of the commercial electronic messages that you're sending them. It could be as easy as a reply to this email with unsubscribe in the subject line, or it could be something more complicated that's built into your website that allows people to unsubscribe. However, it has to be easy and it has to be obvious, and that shouldn't be too hard for you to comply with. Once you've received that unsubscribe as the sender, you have 10 days to comply with the unsubscribe. If you continue sending CEMs 10 days after they've sent you that unsubscribe message, then you are in contravention of Canada's new anti-spam legislation. I hope that clears up a lot of the questions we have in regards to Canada's anti-spam legislation, or CASL as you may hear it referred to as well as any commercial electronic messages or CEMs. And bear in mind that you've got a couple of years, so long as you've been in touch with people over the last 6 months, you've got a couple of years to continue to reach out to them unless they opt out from receiving your CEMs. All right, just finished up on the phone with Jody Conroy, who is a notary public over on the Sunshine Coast, and I had some questions for her in regards to what happens to the amount owing on the Form B when a strata property is being sold by way of a court-ordered sale. And Jody informed me that what happens is the court will issue what's called a vesting order when they are approving the sale that will state that not only are all the charges that are on title to be taken care of before they transfer title, but also any fees that are payable to the strata corporation. Those will be made out and specified in this vesting order. So it's a vesting order from the court that's going to protect your buyers from being responsible to pay those charges that are due to the Strata Corporation. So that part's all under control. But Jody did ask me to remind all of our realtors that when you're representing a buyer in a court-ordered sale, be sure to specify the individual, their legal name on the contract of purchase and sale where it says buyer. If you don't, if you write Jim Smith instead of James Alexander Smith, there's a good chance that it's going to cause not only confusion and problems for closing, but it's also going to be a problem that could be expensive for your client to resolve. So be sure to write the correct legal name of your buyer on the contract of purchase and sale as it will be registered on title at completion. It's a critical element when dealing with court-ordered sales. For those of you who haven't already done so, I'd heartily recommend that you read Wesley McMillan's recent article in Realtor Link, produced by the Real Estate Board of Greater Vancouver. Mr. McMillan, who's a lawyer with Harper Gray, goes on to talk about the pitfalls of dealing with both parking stalls and storage lockers when buying or selling strata properties. The big things that you need to be paying attention to are that parking stalls can be sold as part of the strata unit. So the unit can own the stall. This is perfect. This is exactly what you want to see for your buyers or your sellers, is that the stall is in fact part of the strata unit. However, it can also be held as common property and then assigned to owners, typically, not to the units, but to owners for their beneficial use. And it can be done by a variety of means. But the important component is if these rules or bylaws are not ratified by a 3/4 majority vote by the strata owners at the AGM, then these rules and bylaws cease to be in effect. So you could be buying a unit with the assumption that you're getting a parking stall in perpetuity, but in fact you could stand to lose the rights to that parking stall if in fact 3/4 of the owners don't vote in favor of renewing those rules and bylaws. So there's some huge peril there. Another issue that comes into play is when the parking units have been leased out to a third party for them to handle how the parking is all taken care of, and there's further pitfalls involved in that. So it's really important to understand the type of ownership of the strata unit and the parking stalls and the storage lockers in order to be sure that your buyers are getting what they pay for when coming to purchase a property. So if you're representing a strata corporation, it's really important that you get them to go and seek independent legal advice as to how the situation has unfolded for their particular strata corporation. If you're representing a buyer or seller, Mr. McMillan's recommendation is that they too seek independent legal advice as to their rights to both the storage locker and the parking stalls. And when parking stalls are now selling for upwards of $35,000 in downtown Vancouver, this is becoming more and more important, and you can appreciate that you're putting yourself at risk when you go on to tell a buyer that this parking stall is included in the purchase and it's not. They're going to be coming back looking to you for an explanation and probably for compensation. Dealing with one of our agents on a for sale by owner property whereby they're representing a buyer who wants to purchase a property that's offered for sale on Kijiji. We've never seen the property, haven't set foot in it, but our buyer's asking our realtor to write up the contract of purchase and sale to be sure they're being protected. So how do we go about doing that while still earning a commission? Well, you need to negotiate that commission by one of two ways. Either you need to have an exclusive buyer's agency agreement or a fee agreement with your buyer stating that they're going to pay your commission, or you need to get permission from your buyer to go ahead and negotiate that commission with the seller. And once you've got that instruction in writing from your buyer, you're free to take a fee agreement to the seller and ask that it be signed prior to you submitting your offer for their consideration, and that would protect you if in fact you're able to get a deal done. So be sure to get that specific instruction from your buyers giving you the permission to go and seek your commission from the sellers prior to presenting the offer. We were so lucky to be able to enjoy the sunshine and some time together at the Gordon Harmon Memorial Golf Tournament this Friday. It was unbelievable, a spectacular day up on the Sunshine Coast. I just want to thank everyone that was involved in both supporting the cause as well as putting on the entire event. We raised a lot of money for St. Mary's Hospital and Lionsgate Hospital, and I just want to remind everyone of how lucky we are to live here on the west coast of Canada. If people ever argue the cost of living here on the west coast of Canada, it comes with a price tag because it is so spectacular I'll finish up the video with some shots of my wife and I up at the top of Hollyburn Mountain today. It was an unbelievable day in the snow. Here we are in June, in the snow at the top of the mountain, looking down on one of the most spectacular cities on the planet. I'm Alan Stewart, and remember, nothing succeeds like Sussex.